The courtroom settles into silence as the clerk officially calls the matter before the court. The case of People versus Gillian Kerry. The judge acknowledges the appearance of counsel and immediately turns attention to the defense motion scheduled for argument that afternoon. The issue before the court concerns a motion to compel discovery, and from the very beginning, it is clear the hearing will not be routine. The defense attorney rises and explains that months earlier, in July, a formal request had been submitted seeking potentially exculpatory evidence under the court's discovery rules. According to the defense, the prosecution was required to respond within 21 days, but failed to provide either the requested materials or any meaningful explanation until the eve of the hearing itself. The attorney notes that the prosecution's written response only arrived the previous night, leaving little time to address it before appearing in court. The judge confirms that all filings and responses have been reviewed. With that established, the defense begins outlining exactly what information is being sought. The attorney explains that the defense wants communications involving the alleged victim, Will Hathaway, as well as members of the investigative team and prosecution. Hathaway, the attorney says, is not simply a complaining witness. He is the outgoing township supervisor and, more importantly, a long-time political rival of the defendant. According to the defense, communications between Hathaway, detectives, township personnel, and prosecutors could contain information favorable to the accused. The judge immediately interrupts with a direct question. How does the defense know these communications even exist? The attorney responds carefully at first, saying there is strong reason to believe such communications are real. He points specifically to Detective Parvis, whom he describes as the key investigator handling the technical side of the case. The attorney claims the detective has been communicating with Hathaway's as well as members of the township's IT department. The judge presses harder, asking again how the attorney knows any of this for certain. The defense explains that the information came from the client and from statements allegedly made by Hathaway himself. According to the attorney, Hathaway had discussed emailing with the detective, and investigators had also met with him in person at the township offices. The attorney then attempts to broaden the argument, insisting the case itself should never have resulted in criminal charges. In the defense's view, no actual crime occurred. The attorney describes the matter as little more than an issue involving an old email and an outdated meeting invitation, arguing there was never criminal intent or unlawful conduct by the defendant. But the judge cuts the explanation short and redirects the discussion back to the core issue, proof. The court explains that assumptions are not enough. Simply believing emails might exist does not justify compelling discovery. The judge emphasizes that the defense still has not shown concrete evidence that such communications are actually out there. The attorney responds by arguing that discovery cannot happen unless someone first looks for the materials. He criticizes the prosecution's written response, particularly the wording that stated only on information and belief the materials did not exist. According to the defense, that response was insufficient because it did not clearly state whether prosecutors had actually checked with investigators or law enforcement agencies. The judge disagrees with the criticism and points out that the prosecution's wording may simply reflect the limits of what they know. But the defense continues pressing the issue, insisting that prosecutors have an obligation to investigate materials within the possession of law enforcement and determine whether discoverable evidence exists. Again, the judge returns to the same problem. What specific documents is the defense even claiming are being withheld? The attorney narrows the request somewhat, stating there are likely emails between Detective Parvis and Will Hathaway. In addition, the defense seeks any written communications involving witnesses, sheriff's deputies, or prosecutors connected to the investigation. The judge then asks another crucial question. How exactly does the defense know those emails exist? At this point, the attorney becomes more specific. He claims Hathaway forwarded certain emails involving the detective to another township employee. That, according to the defense, proves the communications exist somewhere within township systems. The judge immediately asks where this employee is and whether anyone has been brought before the court to verify the allegation directly. The attorney admits the employee is not present. The judge continues probing. If the alleged emails were sent using township accounts, then why has the defense not attempted to obtain them directly through township channels or the IT department? The attorney explains that the defendant herself has not been able to access those materials and that a Freedom of Information request had previously been submitted. However, he says the communications at issue may have occurred after the request was made. The judge's patience begins wearing thin. The court reminds the attorney that prosecutors are not responsible for performing the defense's investigative work. While the prosecution must disclose evidence within its possession, the court emphasizes that speculation alone cannot justify forcing prosecutors to search endlessly for materials that may not even exist. As the hearing continues, the judge repeatedly asks whether the defense made any real effort to obtain the alleged communications independently before filing the motion. The attorney answers that filing the motion itself was the attempt to obtain discovery. The judge rejects that reasoning. The court explains that there must first be some credible basis for believing the evidence exists before compelling the prosecution to act. Tension begins building in the courtroom. The judge asks when these alleged communications supposedly took place. The attorney estimates they occurred within the previous couple of weeks, though the explanation remains uncertain and incomplete. Then the prosecutor steps forward to provide important context. According to the prosecutor, the defense recently submitted information prepared by a computer expert. That information related to technical records involving a meeting invitation and an email that had been discussed in the case. The prosecutor explains that because he is not a technical expert himself, he forwarded the material to Detective Parvis for analysis. The prosecutor says Detective Parvis has been attempting to verify the technical claims by reviewing server data and digital header information retained within township systems. As part of that process, the detective may indeed have communicated with township IT personnel. However, the prosecutor stresses a key point. The review is still ongoing, no final report has been completed. No conclusions have been reached. The detective is still in the process of determining whether the defense's technical claims have merit. The prosecutor further explains that delays occurred because a primary township IT employee has been absent on leave while another staff member has been occupied with election-related responsibilities. Once this explanation is fully laid out, the judge begins viewing the matter differently. Instead of a situation involving hidden evidence or intentional non-disclosure, it now appears the defense's own, recently submitted information triggered a new investigation that investigators are still trying to complete. The judge questions why the defense filed such an aggressive motion before the review process had even concluded. From the court's perspective, accusing the prosecution of withholding evidence while investigators are actively examining new information seems premature. The defense attorney insists the motion is not about the future report investigators may eventually create. Rather, he says the request concerns existing communications, especially those involving Will Hathaway. The judge asks whether those communications are simply tied to the same old meeting invitation and technical dispute already discussed. The attorney explains that the meeting invitation itself dates back nearly a year, and argues that the entire criminal case stems from what was essentially an IT-related issue rather than intentional misconduct. Then the defense pivots back toward motive. The attorney argues that Hathaway's role as a political rival is deeply important. According to the defense, Hathaway personally pushed the investigation and encouraged prosecution against the defendant. Because of that, the attorney claims all communications between Hathaway, investigators, and prosecutors could reveal bias or improper influence. The judge acknowledges the argument, but again emphasizes the lack of proof. The defense complains once more about the prosecution's wording, insisting the issue could have been resolved easily if prosecutors had simply stated directly that they checked for emails and found none. The judge responds by explaining that prosecutors can only rely on the information given to them by investigators. If law enforcement says no responsive materials exist, then prosecutors naturally respond based upon that information and belief. The defense attorney he understands that position, but says he still wanted confirmation that someone had actually checked. As the hearing progresses, the judge's frustration increasingly shifts toward the tone of the defense motion itself. The court criticizes portions of the filing that appeared to imply conspiracy or misconduct involving prosecutors and township employees. The judge references one particular allegation involving a township employee named Patricia Reiser, explaining that the motion misleadingly suggested she authorized the complaint when, in reality, the records showed otherwise. The attorney quickly denies intentionally misleading the court. He argues that he merely described Reiser's role within the township and did not explicitly claim she approved the complaint. The judge firmly rejects that explanation, stating the overall impression created by the motion suggested exactly that. The exchange rapidly becomes tense. The attorney attempts to argue back, but the judge abruptly warns him about the manner in which he is addressing the court. The judge makes it clear that courtroom decorum will be maintained and announces a recess before matters escalate further. When proceedings resume, the atmosphere is noticeably calmer. The defense attorney immediately apologizes to the court, explaining that his intensity came from a strong belief in his client's innocence and not from any intention to disrespect the judge. The apology is accepted, and the hearing continues. The judge once again asks the attorney to clearly identify the communications being sought. The defense responds that it wants communications between Will Hathaway and members of the prosecution team, including Detective Parvis and the lead deputy assigned to the case. Again, the judge asks the same critical question: how does the defense know these communications actually exist? This time, the attorney candidly admits he does not truly know. He says the belief is based only on information relayed to him and what he has heard from others. The prosecutor then addresses the court directly and expresses concern about how prior conversations have been characterized by the defense. He explains that statements made during phone discussions later appeared in court filings in ways he believes were inaccurate or misleading. The prosecutor points specifically to the issue of a polygraph examination. According to him, the defense suggested prosecutors were ignoring a favorable private polygraph result, but the prosecutors explains he had clearly stated that only a law enforcement-administered polygraph would carry significance in evaluating the case. He adds that the offer for such a test still stands if the defendant chooses to take it. Turning back to the discovery issue, the prosecutor explains that any references he made to non-discoverable emails concerned internal office communications protected as attorney work product. He then states plainly that he has never exchanged emails with Will Hathaway and is unaware of any improper communications involving prosecutors in the case. As for Detective Parvis, the prosecutor says he has no reports currently indicating email correspondence between the detective and Hathaway. However, he assures the court that if any future report references such communications, those materials will be disclosed to the defense as required by law. Finally, the prosecutor addresses the broader allegations suggested throughout the motion. He rejects any implication that the investigation involved conspiracy, political coordination, or unethical conduct. He emphasizes his ethical obligations and professional responsibilities to the court. By the end of the hearing, the focus has shifted dramatically. What began as a dispute over discovery evolved into a larger conflict about courtroom conduct, credibility, and the dangers of making serious accusations without concrete evidence. The judge appears increasingly skeptical of the defense's claims, particularly because the requested evidence remains largely speculative. Meanwhile, the prosecution maintains that no discoverable evidence has been hidden and that any ongoing review exists only because of technical information recently submitted by the defense itself. As the courtroom finally quiets once again, the legal battle remains unresolved, but one thing has become unmistakably clear. The case is no longer only about the alleged crime. It is now equally about trust, professionalism, and whether suspicion alone can justify accusati